today. I'll make this short, so can everyone kindly switch on your videos and mute your microphone during the session? We'll appreciate that. And if you have any questions during the session, please send it to our group chat and we'll attend to it at the end of the session. Other than that, I'll pass the floor to Dr. Varghese and he will start the session as soon as possible. Thank you.
Yeah. Thank you, Marsha. Good evening to all and welcome to BicTok number 28. Yes, there have been 28 of this before. And today we will spend some time looking at this topic, fast-track arbitrations, nature, implementation, and effectiveness in practice. It is hoped that the next 1 hour or so together will be an enriching time for all, to those who are familiar to arbitration as an ADR tool, as well as to those who are just beginning to have an interest in this increasingly specialized sub-area of litigation, especially and in the administration of justice generally. I believe most of us are familiar with the advantages of having an arbitration. It is often, the hallmarks are often touted as party autonomy, less formality, confidentiality, finality, and also cost and time effectiveness. This is what draws a lot of people to arbitration. More industries are forming specialized arbitrations to cater for disputes within that area of activity. Now, these days, we are also familiar with terms like those who are doing arbitration, or others who are outside the field of arbitrations would hear of words like interim measures, emergency arbitration, summary determination, expert determination, and also fast-track arbitration or expedited procedures. What is fast-track or expedited procedures? Is it a new trend within institutional arbitrations? But it's true that it has gained traction in recent years as against the normal arbitration that takes time and it's almost at the mercy of counsel and parties as when how long it takes to be completed and so on. BICAM, the Borneo International Center for Arbitration Mediation, has put together a panel drawn from amongst eminent arbitrators and arbitration practitioners this evening to help us understand what this fuss about a fast track or expedited procedure is all about. I am merely the moderator to introduce the presenters, the panelists, and generally to ensure that all things move and is kept in order. It's the focus of this evening is actually the input that we will have from the three panelists. It has been agreed among us that we will run this evening's program by way of three presentations. Each panelist has agreed to a certain area of presentation. I'll introduce to them before they come to present their area that they've agreed to cover or share with us. Essentially, the three areas, first one is about the introduction, what fast track or expedited procedure is all about, its features, its availability, and so on. The second presentation will be from the perspective of an arbitration practitioner. What are the advantages? What are the drawbacks that we should look out for? And the third presentation will be from the perspective of an arbitrator. Where would it be effective? In what type of cases? And so on. As said by the Marshal from BICAM just now, we might have time for questions and answers. So if you have some questions and answers, do forward it to the organizers, who will then transmit to us, and we'll see how much of those questions we'll be able to cover. Now, without delaying the matter any further, we go into the first presentation. The first presentation is by Mr. Ruben Subramaniam, or known as Ruben to many of us. He is a partner in the firm Screen in Kuala Lumpur. He was called to the Malaysian bar in 2015. He's a barrister, and currently he is the secretary of the Society of Construction Law Malaysia and a member of the Bar Council Arbitration and Constructions Law Subcommittee. Ruben is a dispute resolution lawyer, especially in the construction and engineering practice of that firm Screen. He has experience in various aspects and stages of construction and engineering projects. He is familiar with the entire range of dispute resolution, not really arbitration and otherwise, so he can give us a comparative picture in a wholesome manner. So without further delay, Mr. Ruben Subramaniam, over to you.
Thank you very much, Dato, for the very kind introduction. And thank you to Bicom for the invitation. I'm very honored to be part of this quite esteemed panel today to be speaking to you all. Can everyone hear me? Yes. I'm just going to share my slide. Hold on. Okay. So as Dato pointed out, I will be speaking on the features of expedited arbitration. My short presentation today will encompass 3 areas. Firstly, it will deal with the features of expedited arbitration, then the threshold for applications, for making an application for expedited arbitration, and then I'll briefly discuss the benefits in relation to expedited arbitration. Now, before I do a dive into the key features, I thought the first thing to address would be what was the harm which expedited arbitration intended to cure. So in a survey carried out by PwC in 2018 and another survey carried out by Queen Mary University in 2016, a large proportion of the respondents said that the main problem with arbitrations that they faced was that it was too costly, in that it was more costly than what they would spend in court, and it was too time consuming. And I must add that even from my own experience, I've had a situation where, of course I'm not naming any names, but the cross-examination of one of my witnesses in the arbitration spanned over 7 or 8 years. You know, when I was a pupil, I joined this arbitration, and we were cross-examining somebody, and I think I eventually became a partner, and the same witness was still on the stand being cross-examined. So these sort of things can sometimes happen, but why does this happen? There are many theories for this. One such theory is, of course, well, party autonomy. You know, parties are generally, they yield a bit more power in arbitrations than they do in court. In court, if the judge tells you to file something by the 10th of January, you are going to file it on 10th of January, and if you don't, you're going to file an application for extension of time. And if you just delay, depending on your opponent, they're going to take objections and all of that. So generally, these procedures are a lot more strict, right? In arbitrations, it can be less so sometimes. So then, to solve this problem, there was a need to create a dispute resolution mechanism which was a bit more cost effective and time effective. Thus, institutions have come up with expedited arbitration routes. And how these institutions cure this problem is by a simplification of the arbitral process and imposing stricter timelines. So this brings us to the features of the expedited arbitration procedure. The first key feature I'll discuss is that the arbitrator has the option of deciding the case based on documents only and without the need for oral hearings. But the application of this differs based on the institution. So for example, the International Chamber of Commerce, ICC, it is a discretion of the arbitrator to conduct the arbitration via documents only, and it can also impose limitations on your written documents which are filed. So for example, you can say your written submissions, maximum 50 pages, your bundle of documents, maximum 500 pages, and nothing more than that. So all these sort of limitations can be imposed. ICDR also, for claims below USD 150,000, it's to be resolved via written submissions unless an oral hearing is necessary. SIAC is interesting in that they have two different features. They have an expedited arbitration feature, which was there since 2010, and in that expedited arbitration, the oral hearings will still be held, but parties can agree for the dispute to be decided on a documents only basis. But SIAC has also introduced a streamlined procedure. This was in 2025. This is for very small claims. I'm not entirely sure of the amount, but I believe it's a much lower threshold. And for the streamlined procedure, it is even shorter than expedited arbitration process, and also it is purely a documents only thing. So then we finally come to BICM. BICM, the default is it's going to be documents only unless an oral hearing is necessary. So why do you see this term, unless oral hearings are necessary? It's because it does not necessarily mean that just because a dispute is less than 2 million USD, that means it's a very straightforward dispute. I primarily deal with construction matters, and we have a lot of construction cases where the dispute is just maybe several 100,000 ringgit, but the number of issues that you have to go into to resolve the disputes are extensive, and it will involve factual cross-examination and whatnot to come to a finding on this dispute. So it doesn't necessarily mean that just because an amount in dispute is lower, that means it's more straightforward. So that's why a lot of these institutions have the wording unless an oral hearing is deemed to be necessary, right? So that arbitral tribunal can decide, or the institution can decide, depending on the facts of that case, whether it is suitable for documents only or whether oral hearings would be required. That is the first key feature. Next is in terms of time limits. Now, time limits is something that differs institution by institution. What I see is that most institutions keep it general and a bit vague. They'll say that the institution has the power to abbreviate the time limits. For example, in BICM's rules, it says BICM has the power to abbreviate the time limits imposed under the rules. Whereas under AIAC has a special fast-track arbitral procedure, and there they have very specific timelines that you need to comply with. And why I think it's necessary, why I think sometimes there are no specific timelines that are put in place, is because these sort of things can differ on a case-to-case basis. So it is best that the arbitral tribunal at that point in time when the application comes in, at that point come to carry out a case management conference and decide what sort of timelines should be imposed at that juncture, depending on the complexity of the case. The next key feature I want to go through is the appointment of a sole arbitrator. So what you will find is that most of these, actually all the arbitral institutions in relation to which have the expedited arbitral procedure say that it's to be decided by a sole arbitrator. So SIAC, ICDR, even ICC and BICM all say it is to be referred to a sole arbitrator unless determined otherwise. ICC makes it a bit more clear to say that notwithstanding an agreement by parties. So, for example, if your arbitration agreement says that it's to have 3 arbitrators that to be appointed, notwithstanding that agreement, if your case is something that falls within the expedited arbitration procedure, the matter will be referred to a sole arbitrator. So that raises the question of whether this goes against party autonomy, right? And this is a question which was addressed by the Singapore High Court in the case of AQZ versus ARA. The question was whether an award rendered by a sole arbitrator in disregard of the parties' explicit agreement to have the dispute decided by 3 arbitrators could be set aside, or its enforcement may be refused by national courts. And I guess I segue to our own Arbitration Act, where Section 37 says one of the grounds for setting aside is that the composition of the arbitral tribunal was not in accordance with the agreement of parties, right? So it's whether if you force a party to go through a sole arbitrator as opposed to 3 arbitrators, does that come to a ground to set aside the award? In Singapore, AQZ versus ARA, the court said SIAC rules have been incorporated into the parties' contract, and therefore the rules together with the rest of the contract must be interpreted purposively. A commercially sensible approach to interpreting the parties' arbitration agreement would be to recognize that the SIAC president does have the discretion to appoint a sole arbitrator. Otherwise, regardless of the complexity of the dispute or the quantum involved, a sole arbitrator can never be appointed to hear the dispute, notwithstanding the incorporation of the SIAC Rules 2010, which provide for the tribunal to be constituted by a sole arbitrator when the expedited procedure is invoked. So in summary, the position is the Singapore High Court recognized that by submitting their dispute to SIAC rules, the parties have implicitly already consented to giving the SIAC president the power to refer the case to a sole arbitrator, regardless of the agreement of the parties to have their dispute decided by 3 arbitrators. So that is the answer to the question. Next, in terms of features of expedited arbitration, is the time limits on the award. Now, most institutions provide for a time limit of 6 months, but the starting date varies. For BicTok, it is 6 months from the constitution of the tribunal. For ICC, it is 6 months from the date the institution transmitted the file to the arbitral tribunal. For HKIAC, it's 6 months from the date of the case management conference. So the starting date differs, but is generally about 6 months. The Stockholm Chamber of Commerce is a bit more stringent in that it's 3 months from the date the matter is referred to the arbitrator. So within 3 months, he has to issue the arbitral award, right? Then that links up to the level of detail in the award, right? So as most of you may know, under Section 33 of our Arbitration Act, for an award to be enforceable and valid, the award must provide reasons for coming up to the decision, for coming up to the award, unless parties have agreed otherwise. So you must provide your reasons unless parties provide otherwise. But so even though there's a shorter timeline, reasons must be provided unless there's an explicit agreement. But BICM, SIAC, and HKIAC have allowed for these reasons to be provided in a summary form, right? So that is that. Reasons can still be provided in a summary form, but you still have to provide reasons unless parties have explicitly agreed that no reasons are to be provided. So that's insofar as the features of expedited arbitration are concerned. Now moving on to the threshold. And when you talk about the threshold, the main thing is that certain institutions have an automatic imposition of the expedited arbitration process, and certain institutions keep it to be elective, that parties can elect to opt for the expedited arbitration process. For example, in ICC, if the amount in dispute does not exceed $2 million USD, it is automatic. It will be via expedited arbitration process. You need to apply to to ICC or the tribunal to opt out of it. You need to make that application. You need to say why it's not suitable for expedited arbitration. Otherwise, by default, it will go to expedited arbitration. Similar for ICDR, that disputes below 250,000 USD, automatic expedited arbitration unless it's determined otherwise. Whereas SIAC and BICM and also I believe HKIAC, it is an elective process that parties can apply provided three conditions, provided they fall within one of three conditions. First is that for SIAC, the dispute amount is less than 6 million USD, or parties have expressly agreed for disputes to go through expedited arbitration, or in situations of exceptional urgency. The same three grounds have been adopted by BICM as well, except for BICM, the amount in dispute cannot exceed 15 million ringgit or the USD equivalent. So that is that in terms of the threshold. Now, just on the final point is in terms of benefits. It's evident that one of the key benefits is that this is going to be a cheaper alternative. As I've mentioned earlier, I've had situations where arbitrations go on for years and years. In this situation, if you go under expedited arbitration with the stringent time limits and the time limits on the award and whatnot, you are looking at having the entire dispute decided within a year or so, or less than that, right? And because there's less procedure involved, because there are likely to be limited submissions, limited documents, limited, these sort of things are going to be limited in nature, this should mean that it would be cheaper. Logically, it should mean that. I don't know whether that occurs in practice. Maybe some firms might say, oh, because we are working around the clock on this matter, we are charging a premium rate or something like that. You never know. So maybe it's not cheaper, but logically speaking, it should be cheaper. So these are the two key benefits. And with that, I believe I have that was my presentation in terms of the key features. Thank you.
Thank you, Mr. Tatwa Ruben, for that exposition of what fast track or expedited arbitration is all about, where it's available, what are the things that we have to look out for. Thanks for that. I think if you just summarize what Ruben was trying to tell us is arbitrations today have become overly formalistic. It's not expeditiously concluding. Some parties and counsel use it as a strategic way to delay judgments or final determination of disputes and so on. And procedures like fast track, expedited are there if we want arbitration not to derail the original objectives of it being a quick, easy, and less costly way of disposing disputes, maintaining confidentiality of the parties, of the issues, of the award, and so on. Thank you once again, Ruben, for that presentation. Now we move on to the next presentation. It's by Miss Janet Lai, and this is from the perspective of an arbitration practitioner counsel, the advantages and drawbacks for opting or being pushed into, as we have been told, into expeditious determination of the dispute, either by fast track process or by the expeditious procedure process. Janet Chai was called to the Malaysian bar in 2006. She's a partner with Chui and Company. She's also a barrister. She's an accredited adjudicator at the AIAC and an arbitrator and panel that BICM. She's also an advocacy trainer under the purview of the Malaysian Bar Council Advocacy Training Committee. Janet's practice focuses on commercial, energy, construction, and engineering disputes. She has trained as a litigator, accumulated experience as an arbitration practitioner. So she's the right person to hear from on the perspective from an practitioner. Janet, over to you.
Thank you so much for that generous introduction, Dato. Good afternoon, good evening to everybody. Thank you so much for logging in today to hear us talk about fast-track arbitration. Now, I'm supposed to give you the pros and cons from an arbitration practitioner counsel perspective. And I think Ruben, in summarizing all the key features of fast-track arbitration and also his narration about the history of how fast-track arbitration came about, I think that has already given us an idea, you know, of actually what are the pros and the cons. So let us just run through it again, summarizing his points. So obviously, fast-track arbitration or expeditious determination is good because of its speed and its efficiency. So you can get to the end of the dispute very quickly. And when you are able to resolve disputes quickly, you reduce the time. You reduce the resources needed. That, in turn, should, in theory, make it cheaper, make it more cost-effective, in theory. So those are the two obvious advantages of fast-track arbitration. Now let's come to the drawbacks of fast-track arbitration. We will eventually get to how do we go about thinking, you know, whether to go for fast-track arbitration, but let's just purely focus on the drawbacks. Because it is faster, then obviously there will be a shorter time. So in a sense, the due process will be limited. You may find that you are not able to fully present your cases and thereby restricting the due process. In turn, you may also find that because of the speed, there is a reduction in the amount and the type of evidence you can present. So which is why it's important to know from the outset, what sort of case is it that you have? Is fast-track arbitration really suitable? And I think Dato' Mampal is going to be able to shed more light on this because he's going to deal with it from the perspective of an arbitrator. Now, going back to the drawbacks, those are not the only two drawbacks that I can think of. I think once you hear the word limited, constrained, reduced, you would then think about, hang on, is this process really going to achieve a fair and equitable outcome? Taking it further, is there going to be potentially what's going to happen to the burden of proof? You know, when you're working against the constraints of time, what then is going to happen to the due process in terms of the rules and in evidentiary rules that were supposed to apply in arbitration? So, of course, in arbitration, people usually opt for it because it affords more flexibility. Like Ruben pointed out, like Dato pointed out in his introduction, arbitration is supposed to offer more flexibility as compared to litigation, as compared to going to court, where you're bound by a very thick set of rules of court, where timeline has been prescribed, and you've also got the Evidence Act, where strict evidentiary matters do require you to do a lot more things to prove even the documents that you're relying on. So arbitration is supposed to offer that sort of flexibility. Parties are able to tone down the strictness in terms of the evidence or the extent of which parties are expected to prove their case. But transforming this from evidentiary proof in a normal arbitration setting to one where you have been put into essentially a pressure cooker, because the arbitrator, like what Ruben pointed out, in most institutional rules, they have only 6 months to come up with an award from the time when the tribunal is formed, or from when the first set of directions have been given. They are then under time constraints to get to the award. So then I query what will then happen to the burden of proof. So I think these are the drawbacks in terms of fast-track arbitration. So therefore, one would really have to consider when a client come to you with a case and there is already an arbitration clause in there. So you need to then consider whether this is a type of case which is suitable for you to then put it into a fast-track arbitration mode. And there are, of course, instances, many situations as well, that fast-track arbitrations is very suitable for. And I think that's the second part of the topic that I am supposed to cover. What are the criteria? What are the steps? What is it that you need to consider before you advise your client into let's apply or opt in for fast-track arbitration? I think before we even consider all of that, I think we need to bear in mind all the drawbacks. I think bearing in mind all the drawbacks will then enable you to advise more comprehensively as to whether fast-track arbitration is suitable. So I've already pointed out the limited due process, reduced evidence, and then of course there will be questions of burden of proof. I think we also need to bear in mind what Ruben has pointed out, how fast-track arbitrations actually take place. Whether you apply to the institution, like BICM or AIAC or SIAC, or is it automatic? So whether you apply for it, whether you opt for it, or whether it is an automatic situation by default, you are in fast-track mode by virtue of the threshold, the monetary threshold of your claim. You have to bear in mind that arbitration at the end of the day is all about party autonomy. So if you opt for arbitration, does it then also mean that you can always opt out? So I just wanted to point out in the AIAC rules, in the AIAC fast-track rules, I think there is an option that at any time during the proceedings, the parties may agree that a fast-track procedure shall no longer apply. Yeah. So putting aside institutional rules that provide parties a clear option or for them to opt out of the fast-track procedure, is even in instances like under BICM rules, I don't think they have this similar provision. Even if the rules don't provide for it, what happens if one of the parties suddenly say that I no longer think that fast-track arbitration is suitable for our dispute because of how things have been progressing in the arbitration? When more things are unraveled, when the party has filed this defense, some other issues have arisen, and then they suddenly realize that actually it's not suitable. What happens then when one of the parties suddenly said that, look, I don't think it can apply, I'm gonna opt out, even if there is no opt-out clause under the institutional rules? I think it's something that we need to think of, because ultimately we want to be able to achieve an award that can be enforced. So if there is going to be potential grounds for setting aside or potential arguments to put it in to file a setting aside application, that is something as practitioners we should bear in mind of. So is there a point in insisting that we should go ahead with the fast-track arbitration when the other side has actually already presented, reservations? That is something an arbitration practitioner will need to bear in mind. Ultimately, the goal is always to achieve an award that you can register and enforce, right? So that is something to bear in mind. Now, I just want to now go through very clearly the criteria to be met and the steps to be taken by counsel, all parties, in when they are thinking whether to avail themselves of the expedited or fast-track mode of procedure. So I just wanted to highlight two main challenges, if you will. The first challenge I feel is always there must be utmost cooperation from the disputing parties. That there must be altruism, that they must be really sincere in wanting to just resolve the arbitration. So like I already pointed out, the challenge is in having both parties agree throughout the arbitration to be bound by whatever they have agreed to in the first place. So if one can opt out, what's the point if you require both sides to stick to the process throughout? So that's the first challenge. I think you will always staying or maintaining a fast-track arbitration, in my view, requires utmost cooperation from both parties. And we all know how things are, right? When parties are in dispute. In most instances, they won't be able to talk to each other. In most instances, the counsel or the solicitors acting for them would also be pressured into not being able to push off what they themselves objectively think is best for the client. It usually is very, very client-driven. The sentiment in a dispute is very, very much client-driven. So bear that in mind. The second challenge is, I think, the mistake of thinking that the monetary disputed amount itself can determine whether fast-track arbitration is suitable. I think that is the most mistakes sometimes some of us make. That because it is low in value, say if it's only a few $100,000, what's the point of going through the full process of arbitration? Let's just go fast track and then get to the end very quickly. So of course, I think it's been pointed out as well that that's not the way to decide on matters. I think monetary threshold is one thing to think about, one of the conditions to think about when you are considering whether to avail yourself of a fast-track arbitration, but it's definitely not the only criteria. You need to also think about what sort of issues are involved. The minute there is a factual dispute, I think most likely it's unless if it is a very simple factual dispute, it is difficult to it is already difficult to ascertain that fast-track arbitration is suitable. Needless to say, if the legal issues itself are complex, where you will take lots of submissions, require lots of clarification, that again would already make the dispute unsuitable. Well, in my view, for arbitration. So to list it down more clearly, there are all in all I think the first criteria you need to think about is assess the issues in dispute. Yeah, what kind of evidence is required? Is your dispute a pure documentary evidence matter? Or is it one that requires the arbitrator to just construe or interpret a clause in an agreement? I think these kind of instances, if it is a pure documentary evidence matter, or it is just a contractual clause interpretation, then yes, fast-track arbitration may be suitable. And you would notice that this type of disputes, it can also apply to disputes of high value. There are many disputes of high value where it is just document-based and actually just concerned interpretation of a clause. So that's the first criteria, assess the issues in dispute. And secondly, once you've determined that it is a document based dispute, you have to also assess, do you have the documents? Is this a matter where your documents are already available? Or do you need to track them down? Or do you need to go through discovery? Because again, if you have to go through discovery, then fast-track arbitration, again, it may not be suitable for you. And sorry, actually, yeah, and also be aware of the rules that your clients may already have agreed to in their arbitration agreement. It is also a policy to assume that all institutions provide for fast track. I think Ruben has covered that already. Not all institutional rules provide for fast track arbitration. LCIA, London Court of International Arbitration, they do not provide for fast track or expedited arbitration process. So BICM definitely does. So if you are considering a fast track arbitration, you definitely should consider BICM. The others are, of course, AIAC, SIAC, and ICC. And fourthly, Ruben has pointed this out, be aware of the specific type. There are some rules, some arbitration rules that have already provided for specified time frame. So I think, for example, I think it is AIAC that already require the party, as you are initiating the notice of arbitration, to also send your statement of claim in a fast-track arbitration. So you have to be aware of the timeline. You can't be initiating a fast-track arbitration and then not realizing that there is actually timelines, strict timelines that you need to abide by, adhere to. And also, Ruben pointed us out, opting for fast-track arbitration means that most of the time the matters are decided based purely on documentary evidence, which means to say you don't have a right to a hearing, an oral hearing before the tribunal. Is this something that your client is prepared to forego? Oral hearing, I mean, in our jurisdiction and in jurisdiction where we rely heavily in an adversarial system, where we rely heavily on the counsel or the lawyers to actually advance the case. In a lot of lay person's mind, it is something that it goes without saying that you need to have an oral hearing. You have to be aware that opting for fast-track arbitration means you are foregoing that right, that entitlement to an oral hearing. So once you've considered these 5 criteria that I've pointed out, then I think if you feel that what you have actually is suitable for fast-track arbitration, then go for it. Definitely, it will help to save a lot of time, bearing in mind that we are talking about from the time the tribunal is put up to the time of the award. In most institutional rules, we are talking only about 6 months. So it definitely is a speedy form of dispute resolution. And thank you very much. That is my part.
Thank you, Janet. Thank you, Janet. You have highlighted some concerns that a party to a dispute and counsel advising parties to dispute should look out for before opting in or opting out or be bound by these fast track provisions. Yes, it's an accelerated and simplified procedure where there's straightforward, maybe factual issues, but what are the implications? The implications, as you pointed out, is on party autonomy, on due process, on hurried justice, where you don't have the opportunity to have witnesses, and where it requires expert views, you might not be able to even call in experts to determine a particular issue. Well, thank you again, Janet, for that input. We now move on. I know we are behind time. We will not restrict you, Dato Manpal, who is our next presenter. He's coming from the perspective of an arbitrator, the type of and disputes where fast track would be ideal and effective, and some insights into significant procedures of fast track. Dato Manpal was admitted to the local Malaysian bar in the year 2000. And he graduated actually from, are we on? He graduated actually from Australia with 2 degrees, law and accounting. He's an associate of the Chartered Institute of Arbitrators. He's also known to many in the legal fraternity as Dato Steve. He will become, and he was experienced in adjudication, arbitration, conveyancing, and litigation. So from that perspective of his experience and as an arbitrator in various matters, he's now going to see how we can also get a feel of fast track procedure insofar as arbitrations are concerned. Dato Manpal, over to you.
Good evening, everyone. Thank you, Dato, for the kind introduction. Now, I am just going to run through very quickly. If you are thinking about fast-track arbitration, start when you are actually drafting the agreement. Because if you are actually thinking about fast-track procedures, you need to incorporate this right from the start when you are drafting your agreement and inserting the arbitration clause. So there are sample arbitration clause given by AIAC as well as BICM. Next one, next slide. Next slide, please, Marshall. Marshall, next slide.
Yeah.
Next slide. Yes. Okay. This is the sample clauses. Now, what has happened in AIAC as well as in the countries surrounding us, like SIAC, HKIAC, right? In AIAC itself, the number of fast-track arbitrations, can we have the next slide, please, Marshall? The number of fast-track arbitrations that have actually been carried out are very minimal. In the year 2023, there were only 5. In the year 2022, which is the next slide, there were only 3. In the year 2021, which is the next slide, there were also only 3 fast-track arbitrations. And in the year 2020, similarly, there were only 3. Now, that shows that not many people are actually quite keen on doing fast-track arbitration. Now, we talked about the time frame for the arbitrator to deliver the award that is provided in the AIAC rules as well as the BICM rules, and the time frame that's given is actually 6 months. Now, is that a reasonable time frame? Is that too short a time to deliver a reasonably good arbitration award? the statistics have shown that despite the time frame being 6 months, the average time taken to complete the arbitration, the domestic arbitrations, is about 10 months. Next slide, Marshall. Marshall, next slide, please. Marshall, are you there? Next slide. Yes.
Okay.
Right. So the domestic arbitrations, the time frame taken on the average is about 10 months. Now we go to SIAC and how they have fared with regards to fast-track arbitration or expedited procedure arbitration. The next slide, please, Marshall. Out of the 143 applications, 66 were accepted in the year 2024. For HKIAC, the next slide, please, Marshall. Out of 24 applications in the year 2024, 13 were granted, 9 were rejected, and 2 were still pending at the end of 2024. For 2023, out of 24 applications, there were 15 granted and 9 rejected. So we see that there are actually not many parties that have been quite keen on taking up fast-track arbitration. Now, obviously, the reasons are because the drawbacks and have outweighed the benefits for this kind of arbitration. Now, next slide, please, Marshall. From the perspective of an arbitrator, now we have to look at which of the rules are actually applicable. Is it the AIAC fast-track procedure, the UNCITRAL expedited rules, or the BICM expedited procedure? In most of the rules, it has to be upon the request of a party. And for AIAC and BICM, there is this requirement that it's either by party agreement or based on the sum in dispute. Now, as far as AIAC rules are concerned, it is for international arbitration, it is USD 300,000. For domestic arbitration, it is 1 million ringgit. And for BICM, as was pointed out by the 2 earlier panelists, it is 15 million ringgit threshold. Now, for UNCITRAL rules, it is only by parties' agreement. There is no threshold dispute sum applicable. Now, my learned fellow panelist was talking about opting out of fast-track arbitration, where it automatically applies in respect of a particular arbitration, a particular dispute, which is referred to arbitration because of the threshold sum being below the certain threshold that is been stipulated in the various rules. Now, for the AIAC and the BICM rules, both allow for opting out. Now, for the AIAC rules, it is either you can opt out either by parties' agreement or a decision by arbitral tribunal in exceptional circumstances. Now, for the and this shall not affect the constitution of the arbitral tribunal, despite the party having opted out subsequent to the fast-track arbitration having commenced. Now, the arbitral tribunal may continue to conduct proceedings pursuant to the respective rules. Now, in BICM, it is contained in Rule 5.5. Rule 5.5 basically says that upon the request of any party, right, and following consultation with both parties and BICM, the arbitral tribunal may order that the parties shall no longer be bound to conduct the proceedings in accordance with the expedited procedure rules. So then we talk about how do you commence fast-track arbitration. In most instances, most of the rules provide that when you communicate your notice of arbitration for fast-track arbitration proceedings, you have to communicate it together with the statement of claim to the opposing party, the appointing authority, as well as the arbitral tribunal upon it being constituted. Next, please, Marshall. Next slide, please, Marshall. Now, the appointment of arbitrator. In most of the rules, including the AIAC and CITRAL, as well as the BICM rules, only a sole arbitrator is appointed despite the agreement of parties to appoint 3 arbitrators. For AIAC, this is specifically entrenched in the rules, whereas for BICM, BICM may decide to appoint more than one arbitrator in circumstances where they consider it fit. Now, consultation with the parties. Now, what happens after the arbitrator is appointed? In AIAC rules, clause 7 particularly, it requires the arbitrator to, within 15 days of constitution of the tribunal, to have a case management. Right? As far as BICM rules are concerned, BICM Rule 13.3 allows for the arbitral tribunal to have a preliminary meeting as soon as practicable after the arbitral tribunal is constituted. Now, it's interesting that, and I think it would be good for the participants to know of a bit of the history. The AIAC rules was first put in a separate booklet, and then it was consolidated into the rules as rule number 8. Subsequent thereto, it was moved to schedule 4 of the AIAC rules. Whereas with regards to BICM rules, it is in together with the other rules that are that stipulate the procedure and practice with regards to arbitration. Now, we talk about then party autonomy versus arbitral tribunal discretion. Now, the arbitral tribunal has a wider scope of discretion in the fast-track procedure, simply because they would need to move things quicker. But of course, this discretion is in most instances, as stated in the rules, subjected to consultation of parties. It is in the AIAC rules. And for BICM rules, it's stated there that except where prohibited by the law, the arbitral tribunal has a rather wide scope of discretion, right? Rule 5.3. Now we go on to the next slide, Marshall. Now the nature of arbitration proceedings, as both the panelists prior to me have pointed out, normally hearings are not the norm in fast-track procedure arbitration, right? It is for AIAC, if there is no request, then the arbitral tribunal would normally dispense with any requirement to hold a hearing. For BICM rules, the arbitral tribunal shall decide the case based on documentary evidence only unless the tribunal itself, after consulting parties, considers hearings necessary. So this is a situation where it is quite clear that things are supposed to be moved fast, and therefore hearings are deemed to actually hinder quick progress of the arbitration. Now, the time frame to deliver the awards is a big concern for many an arbitrator in respect of fast-track procedure, because you only have 6 months from the date of the constitution of the arbitral tribunal. And this is provided for in the AIAC rules as well as the UNCITRAL Article 16, unless otherwise agreed by the parties. Now, why we would not really bank on the agreement by the parties, it is because for the claimant, right, they would generally agree so that a decision can be made quicker. But for the respondent, they may try to stifle things in order to delay the whole process. And this is what Janet has referred to just now. Why? Because we, even in arbitration, are in an adversarial mode, right? What I don't benefit from, I don't agree to, right? So now, arbitral tribunal may, in exceptional circumstances and after consulting the parties, extend the period of time to a period of time not exceeding 9 months from the date of constitution of the arbitral tribunal. This is provided for in the rules, right? However, any further extension for the delivery of the award must be agreed upon by the parties. And this is contained in the AIAC as well as the UNCITRAL rules. Now, for BICM rules, Rule 5.3e specifically provides that the award shall be made within 6 months from the constitution of the arbitral tribunal unless extended in exceptional circumstances by BICM. So it must be exceptional circumstances, and it is within the discretion of the appointing authority, namely BICM. Okay, now we'll just touch a very slight bit on the two case laws that I intend to highlight. Now, the first is the Pan Ocean Container Suppliers Company Limited and Spinnaker Equipment Services Incorporated. Now, this is a very interesting case because what happened in this case is the plaintiff initially refused to participate in the arbitration proceedings. Now, the defendant, who was the claimant in the arbitration proceedings, had applied for the expedited procedure and was granted permission or leave to proceed with the expedited procedure. Now, the respondent, which is the plaintiff, then went to court and said that the defendant, which is the claimant, should have informed the arbitral tribunal when the surrounding circumstances of the arbitral proceedings rendered the expedited procedure no longer appropriate. And the two reasons given for this procedure not being appropriate was because mainly because the amount exceeded the threshold of 25 HK million. Now, the court held this, that the defendant, which was a claimant, did not have any duty to inform the arbitral tribunal that the expedited procedure was no longer applicable or appropriate because of the lackadaisical attitude of the plaintiff, where they refused to participate in the arbitration proceedings. Secondly, the court also held that the tribunal, in awarding the award, had been meticulous and careful in the process of determining the claim of the defendant claimant, and therefore this expedited procedure did not result in what we call rough justice, right? Because the arbitral tribunal was careful to determine the claim and took into account the necessary evidence, then the court said, therefore, we feel that it was not really necessary for the expedited procedure to be abandoned. Now, we then go to the case that my learned friend, learned panelist Tatwa Ruben referred to as well, AQZ and ARA. This was a Singapore case where what happened was that the respondent had disputed the expedited arbitration on the basis that the agreement for arbitration was signed in 2007. And in the 2007 SIAC rules, there was no provision for expedited procedure. However, the arbitral tribunal was requested to apply the expedited procedure in the SIAC rules 2010 when the arbitration had commenced. And so the respondent in that case said, no, you should not have proceeded with expedited procedure arbitration because it was not contained in the rules when I signed the agreement for arbitration. But as what my learned panelists have pointed out, the court has said that irrespective, right, of this, as long as you have subjected or agreed to be subjected to the SIAC rules, right, the version of the rules that would be applicable would be when the arbitration commenced and not when you signed your agreement to arbitrate the matter. And as such, the court ruled that the challenge on the expedited procedure was not a valid challenge. Now, in essence, right? Okay. Now, in contrast to the Malaysian, Singaporean, and Hong Kong experience of having a very low uptake for fast-track arbitration, the ICC International Court of Arbitration had 152 expedited procedure arbitration matters in comparison to the 841 arbitration cases that were registered in the year 2024. So maybe we can actually try to find out what makes their fast-track arbitration procedure so successful that the parties actually opt to do fast-track arbitration in the ICC International Court of Arbitration. Now, I would have a bit of comments which are not in my slide, and I will just state it out now. Now, as what was pointed out by the other panelists, contrary to the belief that fast-track arbitration actually is faster or is less time-consuming or is less resource-consuming, fast-track arbitration requires very focused commitment to carrying out the arbitration within the time span of 6 months for the parties as well as the arbitrator, right? If the parties are not able to commit the resources towards carrying out the arbitration within a short time frame, then it would be advisable to actually opt out of fast-track arbitration. Okay. Equally, for the arbitrator, if the arbitrator does not have the time to spare to complete a fast-track arbitration, then it would be best not to take up the appointment. Now,
yeah.
Yes. Can I
think-
just say a few more things, Dato? Yeah.
Dato, I think we have we are on the what do you call it, goodwill of all the listeners or audience, because we have exceeded the time by 15 minutes. Maybe if you can just summarize in the next 2 minutes.
Yes, I will summarize. Now, what we need to remember is that there can be an inverse relationship between time on the one hand and quality of processes and decision making on the other. So fast-track arbitration may not necessarily give the parties the proper treatment in terms of processes, and may not even result in the right decision at the end of the day, right? Now, some of the factors to consider before agreeing to expedited arbitration is importance of the relationship in commercial and economic terms, the complexity of the relationship, and the nature of recurring disputes, right? The need for document disclosure, right? As what Ms. Janet has pointed out, if you need to discover documents, then most likely fast-track arbitration would not be suitable for you. Expedited arbitrations require intensive effort within a short period of time. Is the client actually ready and able to commit the resources required to support an accelerated arbitration? So with that, I thank you for your ears and for the patience indulging me in the extended time.
Thank you, Dato, for the input and extensive coverage of the various rules and developments as we see it today. I'm not going to add any more comments. I had some because we are past the time. Just that I think overall, I think we have impressed upon our listeners. We have in our own researches found out that it's a speedy process, no doubt. It has strict time limits, but it is something that is intense for both practitioners and arbitrators. It might not meet the ends of justice in certain cases. So it's a conflict between option for rapidity as against due process or ends of justice. So let's leave that at there. Keep the issues in mind, mull over it. I notice that there are no questions. So once again, thank you to the panelists for the good input, for enlightening us on this subject. Thank you to the organizers, BICM office staff, Marshall, Mary, Sharifa, and so on for putting all this together. And we look forward to another session to keep us on focus as far as arbitration and its possibilities are concerned, as organized by BICM for us through this BicTok. Thank you and good night all.
Thank you, Dr. Vargas. Thank you, panelists. Before we leave the session, would it be all right if we take a quick picture?
Sure.
All right. If anybody else would like to join in on the photograph sessions, feel free to turn on your cameras. All right. 1, 2, 3. One more picture. 1, 2, 3. All right. Thank you so much, everyone. I hope you had an enjoyable time. Please have a lovely evening, and we hope to see you for our next BicTok back in August. Thank you so much.
Thank you. Good night, Marshall.
Good night.
Good night.
Bye.
Good night, Ruben. Good night,
Thank you, BICM.
Janet.
Thank you,
Good night,
Dato.
Manpal.
Thank you, everybody. Good night.
Good seeing you, Ruben and Dr. Manpal. Bye.
Bye.